Hey everyone, thank you for clicking on my video today. All right, so in today's episode, I want to talk about the social media addiction case. Um, I have noticed that they've been talking about this on the news a little bit, but I haven't noticed many YouTubers talking about it or even people on social media. But it's very interesting to me, and so I wanted to make a video on it myself. So if you're not familiar with this case, basically what's been happening is really since the beginning of social media, people have been sounding the alarm on the effects of these companies and these services on people's mental health, but especially the mental health of children or young people. And so there's been tons of cases that have been filed against basically all of the major social media companies. And so what seems to have happened is because there's been so many cases being filed in state courts, from what I understand, they've now decided to combine all of these, maybe not all of them, but a lot of these cases. They've decided to combine them into a federal complaint. And then today, what happened is that the very first one went into opening statements. And this case is that started today is happening in California. And there is a minor involved in this case that's going by the initials KGM. And this is the case that has been, if you've been noticing or hearing about it in the news, that's the case that they've been talking about, is the one that's happening in California, because it's the very first one out of all the hundreds that have gotten this far, maybe thousands, but I'll just be conservative and say hundreds. It's the very first one to actually begin trial. And so whatever ends up happening in this case could and likely will set a precedent for what happens with all the other hundreds of cases and this federal case. So in the case with KGM, we already know so far that Snapchat and TikTok have settled. So you might have seen headlines in the news saying that, Snapchat and TikTok settled out of the case. They're talking about this case that just started opening statements today, which is February 9th. They're talking about that case with KGM. They settled out of that one. But they are still, Snapchat and TikTok are still involved or are still defendants in the federal case. What I want to do is, the way I've organized this video is we're going to go through a couple of articles, and then I want to read through the federal case and just look at the introduction and the factual allegations against all of the defendants. Let's start with the first article that I want to go through. So I'm doing something a little bit different today because if you've been watching this channel, you know that I like to go through articles a lot, and the ads were getting on my nerves. So I decided to get this reader view. This is like a reader view Chrome extension. So that's why it looks like this. But this is an article from The Guardian, and it kind of drives the point home about what I'm saying as it relates to why this case with KGM is so important and how it's connected to the federal case and all these other cases, and why almost everything is dependent on what happens with this KGM case. Let's get into it. So this is an article from The Guardian, and it says, tech giants head to landmark US trial over social media addiction claims. And this was, of course, published on the 27th, so it was a little while ago. So it says, for the first time, that's another thing, is that this is the first time that anyone has gotten this far with allegations against these social media companies. That's another reason why this is a big deal. So for the first time, a huge group of parents, teens, and school districts is taking on the world's most powerful social media companies in open court, accusing the tech giants of intentionally designing their products to be addictive. The blockbuster legal proceedings may see multiple CEOs, including Mark Zuckerberg, face harsh questioning. A long-awaited series of trials kicks off in Los Angeles Superior Court on Tuesday. in which hundreds of US families will allege that Meta, Snapchat, TikTok, and YouTube's platforms harm children. Once young people are hooked, the plaintiffs allege they fall prey to depression, these types of activities, and other mental health issues. Approximately 1,600, so I was correct, it's thousands. Approximately 1,600 plaintiffs are included in the proceedings involving more than 350 families and 250 school districts. That's a massive amount of people. The fact that a social media company is going to have to stand trial before a jury is unprecedented. Founder of Social Media Victims Law Center, an attorney representing the plaintiffs, said in a press briefing. The initial trial is expected to last 6 to 8 weeks, and it involves a 19-year-old who is identified in court documents by the initials KGM. She alleges that she developed mental health issues at a young age after becoming addicted to social media apps. Her case will be the first of about 22 bellwether trials, which are used as test cases to gauge juries' reactions and potential verdicts. Ultimately, the landmark trials will cover thousands of lawsuits and have been coordinated in what is known as a Judicial Council Coordination Proceeding, JCCP, and that's the complaint we're going to go through later. The plaintiffs in these cases are seeking financial damages and injunctive relief that would change the design of the platforms and establish industry-wide safety standards. And this is why I want to cover, or part of the reason why I want to cover this case, because depending on how this turns out, we could see massive changes, the fundamental changes to the social media that many of us use regularly. Many of us use every day. And it's going to change industry-wide safety standards depending on how this goes. If they win and prove that millions of children have been harmed by social media, it could profoundly change how these platforms are designed and create new avenues for lawsuits against the tech behemoths. That's not good for them, right? They certainly don't want this. Well, I don't think they want any of this, but they definitely don't want that. Key witnesses are expected to include top executives from the social media companies, such as Snap's CEO. We now know that Snap and TikTok settled out of the KGM case, but like I say, not the other ones. But yes, so Snap CEO, YouTube's high-level people, Instagram, and Zuckerberg, along with experts in online harm. Meta and Snap did not respond to requests, and TikTok declined to comment back when they asked about this. YouTube spokesperson Jose Castaneda called the allegations in the lawsuit simply not true. He said, providing young people with a safer, healthier experience has always been the core of our work, and that, quote, we build services and policies to provide young people with age-appropriate experiences and parents with robust controls, close quote. Troves of unsealed documents and untold harms could be revealed. Just a week before KGM's trial was set to begin, Snap reached a settlement agreement, right? So Snap was like, nope, we're going to settle, with her lawyers, in which the company denied wrongdoing. Financial terms of the settlement were not made public. Snap is still a defendant in other suits, exactly, in the state-level trial, and Meta and YouTube have made no settlement agreements in this case. So just like I was saying earlier, Facebook, Instagram, YouTube are still defendants in the KGM case. Snap said in a statement at the time that the company was pleased to have been able to resolve this matter in an amicable manner. The night before proceedings began, TikTok reached a settlement agreement with the plaintiff, meaning it will not stand trial along Meta and YouTube. The terms of the deal were not disclosed. Sasha Haworth, the executive director of the Tech Oversight Project, which has been involved in advocacy work for plaintiffs, said, you don't settle unless you don't want stuff to be public. The public doesn't really know what is coming. Exactly. And that's what I'm saying. I think the public kind of deserves to know what lengths these companies were going to get people to be addicted to their product. I mean, that's the allegation that these thousands of people have been making, along with other allegations as well. But one of the main allegations is that obviously these companies went out of their way. It was a fundamental design flaw. Well, maybe not a flaw as far as the companies would say, but this was a fundamental design choice to make these products addictive. And if that is the case, then they should be held liable. And we, the public, should know. We should be able to see, I think, what they did. What kind of tactics did they use? What was their thought process in the design of their services? Lawyers for the plaintiffs are using a playbook similar to what was used against tobacco companies in the 1990s, which focused on cigarettes being addictive and companies publicly denying that for decades while knowing their products caused harm. The legal team working on the social media cases say that troves of internal company documents will be unsealed during trial, and the public will hear testimony from children and parents that has never before been revealed. The details of KGM's case have been under seal, but are slated to be made public during trial. Julia Duncan, an attorney with the American Association for Justice, said some of the unsealed documents could show company employees admitting to the addictive nature of the platforms. Court documents say this addictiveness is due to features such as infinite scroll, video autoplay, and the way recommendation algorithms are designed. For example, Duncan said, one unsealed document shows an Instagram employee calling the app a drug, and another employee saying, LOL, we're basically pushers. See, like, I feel like, yeah, the public should see that. The social media companies have argued that how people use their services is up to each individual. These companies have also long maintained they are protected under Section 230 of the Communications Decency Act, right? A federal law that exempts platforms from legal liability for content generated by their users, right? So this is why I'm saying this could be a big deal, because social media companies have been able to skirt around any responsibility that they might have for the harmful nature of their products by relying on this right here. And what that Communications Act basically said was that these companies are not liable for what we post on them, right? So this is how they've used this so many times. This has been like such a, they've used this to get out of a lot of things social media companies have. No matter what situation came up, they would say, well, look, we are not responsible for what people post on our service. All we do is host the content, basically, is what they say. And everybody who uses our service is considered a third party, and we can't be responsible for what people post on our service. And so they're trying to use that in this case as well. So they're saying, well, from the most part, from what I can tell, of course, the trial still needs to take place. So we'll see, hopefully in more detail, what their defense is going to be. But from what I gather, a large part of it is going to be relying on this section to this Communications Decency Act. And what the plaintiffs are going to argue is, no, this is not an issue of what other people are posting. It's the way you designed your product. That's the problem. So that means it's not about this. It's not about what other people posted, what content was generated by users. That's what the plaintiffs are arguing. It's not about that. That's not what we're talking about. We're talking about how you, the company, designed your product fundamentally to be addictive and to be an issue and to try to manipulate people into using your service for as long as possible. You baked certain things into your service to make it addictive, to make it so that people continue to use your product for longer and longer and longer. That is not the same as what these protections. That basically they're saying you're not protected by this because you are responsible for the design of your product. You can't put that on a third party. You're responsible for that. Bergman, KGM's lawyer, said the social media companies operate in the world in a way that no other company does, since they had long been absolved from liability because of Section 230. And I agree. I'm not sure there's any other company in the world that got such blanket protections as social media companies did, and still do. This time was going to be different, he said. The judge in the case ruled in November that jurors must not only look at the content on the platforms, but also the company's design choices. Exactly. There is a lost generation of kids, Bergman said. This was not an accident. This was not a coincidence. This was a design choice. A separate series of federal trials is scheduled to take place in San Francisco in June in what is called a multi-district litigation. That's the one we'll go through today, the MDL. The allegations in these cases are similar to the state trials and involve more than 235 plaintiffs, including families, school districts, and attorney generals from nearly 3 dozen states. The slew of lawsuits comes after several company whistleblowers have spoken out publicly, alleging the social media companies knew their products were harming children and did little to nothing to halt it. A bipartisan group of U.S. lawmakers have repeatedly grilled company executives in congressional hearings, alleging the businesses push content to youth that promotes bullying, drug abuse, and self-harm. Every parent is struggling with their kids and these platforms. Every parent, said Julia Arnold, a founding member of Parents Rise, whose teenage daughter died in 2022 from overdosing on deadly pills after messaging a dealer on Instagram. We've been waiting for this for years, to let the truth come out. Okay, so I think that article really encompasses why this is important, why this is a big deal, why there's a lot riding on the KGM case. Okay, so speaking of the KGM case, I think we should go next to the article that talks about what happened today. Okay, so this is an article from ABC News 7, which is a local station in Los Angeles. And they posted this earlier today. Okay, so it says, landmark trial accusing social media companies of addicting children to their platforms begins. The world's biggest social media companies face several landmark trials this year that seek to hold them responsible for harms to children who use their platforms. Opening statements for the first in Los Angeles County Superior Court began on Monday. Instagram's parent company, Meta, and Google's YouTube face claims that their platforms deliberately addict and harm children. TikTok and Snap, which were originally named in the lawsuit, settled for undisclosed sums. Jurors got their first glimpse into what will be a lengthy trial characterized by dueling narratives from the plaintiffs and the 2 remaining social media companies named as defendants. Opening arguments in the landmark case began Monday at the Spring Street Courthouse in downtown Los Angeles. Mark Lanier delivered the opening statement for the plaintiffs first, in a lively display where he said the case is as easy as ABC, which he said stands for addicting the brains of children. He called Meta and Google 2 of the richest corporations in history who have engineered addiction in children's brains. At the core of the Los Angeles case is a 19-year-old identified only by the initials KGM, whose case could determine how thousands of other similar lawsuits against social media companies will play out. She and 2 other plaintiffs have been selected for bellwether trials, essentially test cases, right? So depending on how these go, it might affect all these other cases. It's the first time. This is crazy. As long as these companies have been around, I find that a little bit crazy that this is the first time. But it's the first time the companies are arguing their case before a jury, and the outcome could have profound effects on their businesses and how they will handle children using their platforms. Lanier said the company's lawyers will try to blame the little girl and her parents for the trap they built, referencing the plaintiff. She was a minor when she said she became addicted to social media platforms, which she claims had a detrimental impact on her mental health. Lanier said that despite the public position of Meta and YouTube being that they work to protect children and implement safeguards for their use of the platforms, their internal documents show an entirely different position, with explicit references to young children being listed as their target audience. Lanier also drew comparisons between the social media companies and tobacco firms, citing internal communications between Meta employees who were concerned about the company's lack of proactive action about the potential harm their platforms can have on children and teens. For a teenager, social validation is survival, Lanier said. The defendants engineered a feature that caters to a minor's craving for social validation, he added, speaking about the like button and similar features. The court broke over lunch before Lanier concluded his opening statement and before attorneys Meta and Google delivered their opening statements. This was only the first case. There are hundreds of parents and school districts in the social media addiction trials that start today. And sadly, new families every day who are speaking out and bringing big tech to court for its deliberately harmful products, said Sasha Haworth, executive director for the nonprofit of Tech Oversight Project. Jurors are not being asked to stop using Facebook, Instagram, YouTube. Okay, so they're not being sequestered. Okay, jurors are not being asked to stop using Facebook, Instagram, YouTube, or any other forms of social media throughout the course of the trial, which is expected to last about 8 weeks. But Judge Carolyn B. Cole emphasized that they should not make any changes to the way they interact with the platforms, including changing their settings or creating new accounts. Okay, that's interesting. Cull said that jurors should decide the liability of Meta and YouTube independently when they deliberate. A separate trial in New Mexico, meanwhile, was also set to kick off with opening arguments on Monday. KGM claims that her use of social media from an early age addicted her to the technology and exacerbated depression and negative thoughts. Importantly, the lawsuit claims that this was done through deliberate design choices. Through deliberate design choices made by companies that sought to make their platforms more addictive to children to boost profits. This argument, if successful, could sidestep the company's First Amendment shield and Section 230, which protects tech companies from liability for material posted on their platforms. Borrowing heavily from the behavioral and neurobiological techniques used by slot machines and exploited by the cigarette industry, defendants deliberately embedded in their products an array of design features aimed at maximizing youth engagement and to drive advertising revenue, the lawsuit says. The tech companies dispute the claims that their products deliberately harm children, citing a bevy of safeguards they have added over the years and arguing that they are not liable for content posted on their site by third parties. I don't think this is going to work. If they really, because that's not what this is about. It's not about what other people are posting on your content. It's about the design choices. It's about the fundamental choices you all made as a company. But I know they're going to try because this has always worked for them in the past. A Meta spokesperson said in recent statements that the company strongly disagrees with the allegations outlined in the lawsuit and that it's confident the evidence will show our longstanding commitment to supporting young people. Okay? And then Jose Castaneda, a Google spokesperson, said that the allegations against YouTube are simply not true. Right, we read that. And then the rest of this article mostly just recaps a lot of what we read in the first article, and it talks about what other countries have done to protect themselves. The United States, as far as I can tell, has not done anything, but it seems like some other countries have. So Australia and other countries have moved to put further protections in place, because apparently the social media companies don't want to do it themselves. That basically gets us up to date on what's been happening in the KGM case, or at least what happened today and this week. Okay, so now I want to move to the federal case, and let's look at what they're actually being accused of, what they're accusing them of doing. Okay, so here we go. So just a reminder, this is the federal case. American children are suffering an unprecedented mental health crisis fueled by defendants' addictive and dangerous social media products. In the past decade, Americans' engagement with social media grew exponentially, nowhere more dramatically than among our country's youth. That explosion in usage is no accident. It is a result of defendants' studied efforts to induce young people to compulsively use their products: Instagram, Facebook, TikTok, Snapchat, and YouTube. Borrowing heavily from the behavioral and neurobiological techniques used by slot machines and exploited by the cigarette industry, defendants deliberately embedded in their products an array of design features aimed at maximizing youth engagement to drive advertising revenue. Defendants know children are in a developmental stage that leaves them particularly vulnerable to the addictive effects of these features. Defendants target them anyway, in pursuit of additional profit. The defects in defendants' products vary by platform, but all exploit children and adolescents. They include, but are not limited to, an algorithmically generated endless feed to keep users scrolling in an induced flow state, intermittent variable rewards that manipulate dopamine delivery to intensify use, trophies to reward extreme usage, metrics and graphics to exploit social comparison, incessant notifications that encourage repetitive account checking by manufacturing insecurity, inadequate, essentially illusory age verification protocols, and deficient tools for parents that create the illusion of control. The resulting ubiquity of defendants' products in the lives and palms of our kids and the ensuing harm to them is hard to overstate. Today, over a third of 13 to 17-year-old kids report using one of defendants' apps almost constantly and admit this is too much. Yet more than half of these kids report that they would struggle to cut back on their social media use. Instead of feeding coins into machines, kids are feeding defendants' platforms with an endless supply of attention, time, and data. Defendants' choices have generated extraordinary corporate profits and yielded immense tragedy. Unalive rates for youth are up an alarming 57%. Emergency room visits for anxiety disorders are up 117%. In the decade leading up to 2020, there was a 40% increase in high school students reporting persistent sadness and hopelessness, and a 36% increase in those who attempted to take their own lives. In 2019, 1 in 5 schoolgirls had to make an unalive plan. In 2021, 1 in 3 girls seriously considered unaliving themselves. Children and their parents and guardians across the country have struggled to cope with the severe, lasting damage visited on their families by anxiety, depression, addiction, disordered eating, self-harm, and the loss of outliving one's child. This lawsuit follows on a growing body of scientific research, including defendants' own internal, previously concealed, that's important, I think, previously concealed studies that draws a direct line between defendants' conscious, intentional design choices and the youth mental health crisis gripping our nation. Instagram, Facebook, TikTok, Snapchat, and YouTube have rewired how our kids think, feel, and behave. Disconnected likes have replaced the intimacy of adolescent friendship. Mindless scrolling has displaced the creativity of play and sport. While presented as social, defendants' products have in a myriad of ways promoted disconnection, disassociation, and a legion of resulting mental and physical harms. The U.S. Surgeon General recently explained that children versus big tech is just not a fair fight. You have some of the best designers and product developers in the world who have designed these products to make sure people are maximizing the amount of time they spend on these platforms. And if we tell a child, use the force of your willpower to control how much time you're spending, you're pitting a child against the world's greatest product designers. Over the past year, hundreds of personal injury actions have been filed in court across the country, alleging that defendants defectively designed their platforms in foreseeably unsafe, this is another thing here, in foreseeably unsafe ways and in a dereliction of their basic duties of care. This was totally foreseeable. You know that this was going to be harmful. That's what the plaintiffs are saying about the social media companies. You knew that this was going to be harmful, and yet you still continued. Plaintiffs in these cases are the young people across the country whose descent into the void of social media has led to serious and sometimes fatal harm, and their parents and guardians. Defendants are the multi-billion-dollar corporations who designed unsafe products that hopelessly outmatch parents' struggle to keep their children healthy and safe. Over the past decade, defendants have relentlessly pursued a strategy of growth at all costs, recklessly ignoring the impact of their products on children's mental and physical health and well-being. In a race to corner the valuable but untapped market of tween and teen users, each defendant designed product features to promote repetitive, uncontrollable use by kids. Adolescents and children are central to the defendant's business model. These age groups are highly connected to the internet, more likely to have social media accounts, and more likely to devote their downtime to social media usage. Additionally, youth influence the behavior of their parents and younger siblings. As one defender put it, losing the teen foothold in the US would mean losing the pipeline for growth. Recognizing the power of engaging young users, defendants deliberately tweaked the design and operation of their apps to exploit the psychology and neurophysiology of kids. Because children's and adolescents' brains are not fully developed, they lack the same emotional maturity, impulse control, and psychological resiliency as adults. I would argue that there's still many adults that are addicted to social media, but I get what they're saying. Children are more susceptible. As a result, they are uniquely susceptible to addictive features in digital products and highly vulnerable to the consequent harms. Knowing this, defendants wrote code designed to manipulate dopamine release in children's developing brains, and in doing so, create compulsive use of their apps. Defendants' strategy paid off. Users of their products now number in the billions, and the frequency and time spent by these users has grown exponentially. This has allowed defendants to harvest a vast amount of personal user data, from the school you attend, to the sneakers you covet, to the places you've been and the people you've met. This, in turn, has allowed defendants to mint a fortune by selling to others the ability to micro-target advertisements to incredibly narrow slices of the public. Which, this part, I think many of us know today about how, they target people. They build these profiles based off what you put on social media and everything else, and they're able to target you with ads. And they're getting increasingly better at that, might I add. Sometimes a little scarily good at it. Defendants' growth has come at the expense of its most vulnerable users, children around the world, including plaintiffs, who they cultivated and exploited. Plaintiffs are not merely the collateral damage of defendants' products. They are the direct victims of the intentional product design. See how they continue? The intentional product design choices made by each defendant. They are the intended targets of the harmful features that pushes them into self-destructive feedback loops. As a direct result of defendants' successful promotion of their defective products, the rates of mental health issues among children have climbed steadily since 2010. By 2018, unalive was the second leading cause of death for youth. In late 2021, the U.S. Surgeon General issued an advisory to highlight the urgent need to address the nation's youth mental health crisis. In a scathing rebuke of the assault on our children, the Surgeon General recognized the dangerous designs in the defendant's products and defendants' abdication of responsibility for the resulting harms. In my brain, I kind of tie this argument and what's happening with social media, I think is also going to end up being litigated against AI companies as well, for similar reasons. I feel like the AI companies, very similarly to social media companies, have just released their product onto the public, and it is causing harm. We know for sure. We know for sure social media is causing harm. I know the companies want to fight about that. The social media companies would beg to differ. And sure, we can listen to their arguments and see what happens in these cases. But we also know even in AI, similar things are happening where there's harm being done. People are no longer on this earth due to conversations that they've had with AI chatbots, and people are launching lawsuits against them. And so I feel like the conversation that's happening over there with those companies is a similar conversation that's happening here, where the social media companies came out of the gate, they just unleashed these products and these services onto the unassuming public, and we're using them, and they're manipulating, according to this lawsuit, they are deliberately going in there and trying to make these products as addictive as possible on purpose. And in some ways, I think the AI companies are doing a similar strategy with these chatbots. They want people to be talking to them as much as possible. Another thing I'm wondering is, will these cases have, and how they're handled, also have an effect on how we view AI and some of these cases that are playing out over there too, and vice versa? We'll see. In these digital public spaces, which are privately owned and tend to be run for profit, there can be a tension between what's best for the technology company and what's best for the individual user or for society. Business models are often built around maximizing user engagement as opposed to safeguarding users' health and ensuring the users engage with one another in safe and healthy ways. Technology companies must step up and take responsibility for creating a safe digital environment for children and youth. I would argue they're responsible for that for adults as well, but okay. I agree, especially for children, but really, they're the ones that have a business that we are participating in. I understand there's a level of responsibility there as the public where you could choose not to use it. I get that. But they're the big multi-billion dollar corporation. They have a level of social responsibility to make sure that they're not deliberately causing harm against anyone, not just children and youth, especially them, of course, but I think all of society too. Today, most companies are not transparent about the impact of their products, which prevents parents and young people from making informed decisions and researchers from identifying problems and solutions. The Surgeon General's comments have since been echoed by President Biden himself. So this was filed in 2023. I think I forgot to mention that. So at that time, President Biden was in office. In both his 2022 and 2023 State of the Union address, the president urged the nation to hold social media platforms accountable for the national experiment they're conducting on our children for profit. I would argue AI companies are doing something similar. Defendants knew or should have known about the risks of such addiction, with at least one defendant calling problematic use. Interesting. They could have changed their products to avoid harm. They could have warned the public and plaintiffs about the danger. Instead, defendants placed growth first. Okay, so here are the factual allegations, and this is going to be the general, so this is against all the defendants. So 1, defendants have targeted children as a core market. Each defendant has designed, engineered, marketed, and operated its products to maximize the number of children who download and use them compulsively. Children are more vulnerable users and have more free time on their hands than their adult counterparts. Because children use defendants' products more, they see more ads, and as a result, generate more ad revenue for defendants. Young users also generate a trove of data about their preferences, habits, and behaviors. That information is defendants' most valuable commodity. Defendants mine and commodify that data, including by selling to advertisers the ability to reach incredibly narrow tranches of the population, including children. Each defendant placed its apps into the stream of commerce and generated revenues through the distribution of those apps at the expense of the consuming public and plaintiffs. This exploitation of children, including each of the individual plaintiffs in these actions, has become central to defendants' profitability. Like the cigarette industry, a generation earlier, defendants understand that a child user today becomes an adult user tomorrow. Indeed, defendants' insatiable appetite for growth has created a need for younger and younger users. Defendants wrongfully acquired knowledge Oh, that's interesting. Defendants wrongfully acquire knowledge of their children. How do they do that? Maybe they will explain. Defendants wrongfully acquired knowledge of their childhood user base has allowed them to develop product designs to target elementary school age children who are uniquely vulnerable. Like Joe Camel of old, defendants recent attempts to capture pre-adolescent audiences include kid versions of apps that are designed to fuel kids' interest in the grown-up version. Recognizing the vulnerability of children under 13, particularly in the internet age, Congress enacted the Children's Online Privacy Protection Act in 1999. Right, and that's supposed to protect them from this sort of behavior, is basically what they're saying. Here they are explaining. COPPA was enacted precisely because Congress recognized that children under age 13 are particularly vulnerable to being taken advantage of by unscrupulous website operators. Contemporaneous testimony by the chairman of the FTC observed that the internet makes it easy for children to disclose personal information to the general public without their parents' awareness or consent. Such public disclosures raise safety concerns. Further, the practice of collecting personal identifying information directly from children without parental consent is clearly troubling, since it teaches children to reveal their personal information to strangers and circumvent parental control over their family's information. None of the defendants conduct proper age verification or authentication. Instead, each defendant leaves its user to self-report their age. This unenforceable and facially inadequate system allows children under 13 to easily create accounts on defendants' apps. And I think they have tried to, there's been some talk online about them trying to change this and making people submit their IDs. I don't know if that's the answer. I certainly don't feel comfortable doing that. So I don't know how they address this. I agree with this point, but I also can see from the social media company's point of view that this is really difficult. And in some ways, I understand what they mean, that this is a very difficult problem to solve. This is particularly egregious for two reasons. First, defendants have long been on notice of the problem. For instance, in May 2011, Consumer Reports reported the troubling news that 7.5 million children under 13 were on Facebook. Second, given that defendants have developed and utilized age estimation algorithms for the purpose of selling user data and targeted advertisements, defendants could readily use these algorithms to prevent children under 13 from accessing their products, but choose not to do so. Instead, they have turned a blind eye to collecting children's data in violation of COPPA. Defendants have done this because children are financially lucrative, particularly when they are addicted to defendants' apps. Factual allegation number 2. Children are uniquely susceptible to harm from defendants' apps. Young people are not only defendants' most lucrative market, but are also those most vulnerable to harms resulting from defendants' products. Everyone innately responds to social approval, but some demographics, in particular teenagers, are more vulnerable to it than others. Unlike adults who tend to have a fixed sense of self that relies less on feedback from peers, adolescents are in a period of personal and social identity formation that is now reliant on social media. To understand the impact defendants' apps have on young people, it is helpful to understand some basics about the human brain. So in this part, they're going to lots of science to basically explain why young people, they even have a graph here, young people are still developing, basically, as we all know, and because of that, they are highly susceptible to manipulation like this. Factual allegation number 3. Defendants designed their apps to attract and addict youth. Instagram, Facebook, TikTok, Snap, and YouTube employ many similar defective and dangerous product features that are engineered to induce more use by young people. Actually, I think I want this whole thing. Creating an unreasonable risk of compulsive use and addiction. For instance, all 5 apps harvest user data and use this information to generate and push algorithmically tailored feeds of photos and videos. And all 5 include methods through which approval can be expressed and received, such as likes, hearts, comments, shares, or reposts. This section explains the psychological and social mechanisms exploited by these and other product defects. First, defendants' apps are designed and engineered to methodically but unpredictably space out dopamine-triggered rewards with dopamine gaps. The unpredictability is key because paradoxically, intermittent variable rewards create stronger associations than fixed rewards. Products that use this technique are highly addictive or habit forming. IVR is based on insights from behavioral science dating back to research in the 1950s by Harvard psychologist B.F. Skinner. Skinner found that laboratory mice responded most voraciously to unpredictable rewards. In one famous experiment, mice that pushed a lever received a variable reward. Oh, yes. I'm familiar with this. This is when, So the result was that they kept, the mice were not sure if they were going to get something or not. And so they just kept hitting the lever, like compulsively. The IVR aspect of slot machines is limited by the fact that they deliver rewards in a randomized manner, irrespective of the person pulling the lever. By contrast, defendants' apps are designed to purposely withhold and release rewards on a schedule. Its algorithms have determined it is optimal to heighten a specific user's craving and keep them using the product. See, and this is the part, I find this section very interesting, and that's this right here. I want to know if it comes out and it becomes public. I would really like to see the internal documents of them discussing how they developed this and why. Because I think that would again show, and the plaintiffs would be able to argue successfully that this was absolutely intentional and it was a design choice and has nothing to do with the third-party content being posted on their various sites. Then it says, for example, TikTok will at times delay a video it knows a user will like until the moment before it anticipates the user would otherwise log out. Wow. Instagram's notification algorithm will at times determine that a particular user's engagement will be maximized if the app withholds likes on their posts and then later delivers them in a large burst of notifications. Defendants' use of IVR is particularly effective on and dangerous for adolescents, given the incomplete aspects of their brain maturation described above, including lack of impulse control and reduced executive functions. There are multiple types of dopamine neurons that are connected with distinct brain networks and have distinct roles in motivational control. Apart from the dopamine reward loop triggered by positive feedback, other dopamine neurons are impacted by salient but non-rewarding stimuli and even painful adverse stimuli. Defendants' apps capitalize on this by algorithmically ranking photos and videos that engage users because they present a dopamine payoff, including novel, aversive, and alarming images. Second, there are multiple types of dopamine neurons that are connected with distinct brain networks and have distinct roles in motivational control. Apart from the dopamine reward loop triggered by positive feedback, other dopamine neurons are impacted by salient but non-rewarding stimuli and even painful adverse stimuli. Defendants' apps capitalize on this by algorithmically ranking photos and videos that engage users because they present a dopamine payoff, including novel, aversive, and alarming images. Third, dangerous and defective features in defendants' apps manipulate young users through their exploitation of reciprocity. The psychological phenomenon by which people respond to positive or hostile actions in kind. Reciprocity means that people respond in a friendly manner to friendly actions and with negative retaliation to hostile actions. Products like Instagram and Snapchat exploit reciprocity by, for example, automatically telling a sender when their message is seen, instead of letting the recipient avoid disclosing whether it was viewed. Consequently, the recipient feels more obligated to respond immediately, keeping users on the product. Fourth, defendants' apps addict young users by preying on their already heightened need for social comparison and interpersonal feedback seeking. Because of their relatively underdeveloped prefrontal cortex, young people are already predisposed to status anxieties, beauty comparisons, and a desire for social validation. Defendants' apps encourage repetitive usage by dramatically amplifying those insecurities. Chief Science Officer for the American Psychology Association has explained that online and real-world interactions are fundamentally different. For example, in the real world, no public ledger tallies the numbers of consecutive days friends speak. Similarly, after you walk away from a regular conversation, you don't know if the other person liked it or if anyone else liked it. By contrast, a product defect like the snap streak creates exactly such artificial forms of feedback. On defendants' apps, friends and even complete strangers can deliver or withhold dopamine-laced likes, comments, views, or follows. The like feature on Facebook, Instagram, TikTok, and YouTube, or other comparable features common to the defendant's products have an especially powerful effect on teenagers and can neurologically alter their perception of online posts. Researchers at UCLA found that girls' perception of a photo changed depending on the number of likes it had generated. That an image that was highly liked, regardless of its content, instinctively caused the girls to prefer it. As the researchers put it, teens react to perceived endorsements, even if likes on social media are often fake, purchased, or manufactured. The design of the defendants' apps also encourages unhealthy, negative social comparisons, which in turn cause body image issues and related mental and physical disorders. On defendants' apps, users disproportionately post idealized content, misrepresenting their lives. That is made worse by appearance-altering filters built into defendants' apps, which underscore conventional standards of beauty, and by allowing users to remove blemishes, make bodies and faces appear thinner, and lighten skin tone. Defendants' apps provide a continuous stream of these filters and fake appearances and experiences. That encourages harmful body image comparisons by adolescents, who begin to negatively perceive their own appearance and believe that their bodies, and indeed their lives, are comparatively worse. Fifth, defendants' respective product features work in combination to create and maintain a user's flow state, a hyper-focused hypnotic state, where bodily movements are reflexive and the user is totally immersed in smoothly rotating through aspects of the social media product. As discussed in more detail below, defective features like the ones just described can cause or contribute to, and with respect to plaintiffs have caused and contributed to, the following injuries in young people: disordered eating, depressive disorders, anxiety disorders, sleep disorders, trauma and stressor-related disorders, obsessive compulsive and related disorders, disruptive, impulse control, and conduct disorders, unalive ideation, self-harm, and unalive. Okay, so this is actually much longer than I thought it was going to be, probably because I added those articles as well. So I think I'm gonna have to stop this video here, and then I will have to make a part 2 to read through the rest of these allegations. I hope that you can see as I've been going through all of this that there is so much more to this, that the arguments being put forth by the plaintiffs are more in depth, and I think these companies, the social media companies, are going to have to come up with something more than just relying on the First Amendment and relying on that Special Communications Act. My hope is to film the rest of this and to do a part 2 where I go through the rest of the factual allegations just against all parties. And and then we will continue our coverage of this case. Anyway, so if you've made it all the way to the end, thank you so much for watching. And I will absolutely do my best to get this part 2 out as soon as possible. And there's, of course, other stories that I want to cover. And so hopefully you will stick around, like and subscribe the video. Thank you so much for watching, and I will catch you in the next one.